Welcome to All Things Policy, a daily podcast by the Takshashila Institution. We are a bunch of policy nerds based in Bengaluru, and we like bringing fresh perspectives to Indian affairs and Indian perspectives to global affairs. So grab a cup of coffee, sit back, and join us for today's chat.
Hello and welcome to another episode of
All Things Policy. Today, we want to talk about the right to property. The right to property in India has seen through some ups and downs in its journey. The Constitution originally provided for the right to property under Articles 19 and 31. Article 19 guaranteed to all citizens the right to acquire, hold, and dispose of property. Article 31 provided that no person shall be deprived of his property save by the authority of law. This is something to which we'll come back. The provisions relating to the right to property were changed a number of times. The 44th Amendment of 1978 famously removed the right to property from the list of fundamental rights. A new provision, Article 300A, was introduced, which gave the right to property a legal status. Enmeshed in this debate about the right to property is the rather fundamental question about economic freedom, individual rights being subservient to a vague notion of the common good, and ideas about the interaction between the state and the individual in the economic realm. I have Shrikrishna with me, usually a boring lawyer, but today who will be a brilliant lawyer who will tell us about the evolution of the right to property and where it currently stands. On the way, we hope to highlight some of these interesting debates that have taken place. See, let's start with this. You eloquently started with the idea that the right to property is the greatest casualty in the war between the parliament and the Supreme Court over the supremacy of the Constitution. I love that phrase that you said. Elaborate on that.
Right. Thanks, Anupam. And before I elaborate, like you asked me to, today's episode promises to be very interesting because we're going to delve into a lot of history, constitutional history, the development of constitutional law in our country, right to property, like you mentioned, a lot of politics around it, emergency. A bunch of these elements will come together to make one of the most fascinating stories of post-independence India. And I promise to you and to all our listeners that this is not going to be boring. It's going to be very interesting because there's so much to unpack here, right? And let's begin by the conclusion had put forth before you earlier that, right to property is the greatest casualty in this battle between the parliament on one hand and the courts on the other over supremacy of the constitution, right? So there are two sort of elements to it. One is right to property itself. The other is the supremacy over constitution, which actually means who has the final say on constitutional amendments. Can the parliament amend the constitution as it pleases, or do the courts have some say in this? Right, and both of these stories sort of interconnect at one juncture where they finally meet in the famous case of Keshwananda Bharati and basic structure and so on, for those who may be familiar. But we'll come to that because we are getting ahead of ourselves, right? Let's talk a little bit on the fundamental right to property which existed. And by the way, this was one of the most debated articles in the Constitution itself. The Constitution Assembly members were up in arms against having a constitutionally guaranteed fundamental right to property because, the flavor of the day was socialism. A lot of these Constituent Assembly members did not want fundamental rights to property in the Constitution. But ultimately, in the draft that was agreed to and later accepted, we did get a fundamental right to property in Article 19 and 31, like you pointed out. And 19 basically says that you had the fundamental right to acquire, hold, and dispose property, but this is subject to some reasonable restrictions in the interest of general public. Similarly, Article 31 says no person can be deprived of property. Here we are talking about deprivation of property, where the state can take it away from you without the authority of law. That means only Parliament can make a law and deprive a citizen of his property. But 31 also said that there is a fundamental right to get compensation for the property that has been deprived from you, right? And this compensation is a very, very crucial thing in our story because a lot of battle is fought over this, right? So you can see there's a balance here. There's a fundamental right to property, but there are some reasonable restrictions. State cannot take away property arbitrarily. There has to be a law, but the state also has to pay compensation, right? So this just shows you that our Constituent Assembly framers struck a balance between these two competing ideas of individual rights and liberties and socialistic leanings on the other hand.
Which seems to be, if I'm not mistaken, Sri, more or less the balance that they try to strike with everything, right? As in all the other fundamental rights as well. For example, we don't have absolute freedom of speech. It is freedom of speech subject to reasonable restrictions. We don't have absolute freedom for trade or any of those things, right? that idea of reasonable restrictions always exist within the setup that the original kind of constitutional framers put in. Now, while I mean, we're probably getting out on a tangent already, but while I think I agree with, or I can see why those reasonable restrictions were put forward, given that India was in a newly born state, there were competing kind of political pressures, there was a whole bunch of things happening, and so therefore they had to put that reasonable restrictions in place. I also think that we are more or less slightly disserviced by the existence of that reasonable restrictions as we go on, because that has fundamentally given almost a blank check for both the courts and parliament
Yeah.
to trot upon a right every now and then under this guise, under this very vague guise of reasonable restrictions. But we'll leave that
Right.
aside for the moment. I just wanted to have my say on that bit because
Yeah.
it always irritates me when I hear reasonable restrictions. But
Yeah.
back to you. So in 1950, we had right to property subject to reasonable restrictions. What happened?
Right. A short response to your bit on reasonable restrictions. Once a famous jurist remarked that, the parliament, the government, and the courts have to keep in mind that the right is fundamental and not the restriction, right? You have to keep rights in mind, and these restrictions only come much later. Anyway, that's a separate debate. But, just to talk about this balance which the framers struck, a lot of these socialist sort of principles were moved to this directive principles chapter in the constitution, right? We had a whole bunch of DPSPs which served as the guiding principles for the government's policy. And I'll just highlight one, Article 39 here, because it is important for our story later on. Right? Now, Article 39, two of its clauses basically said that state must direct its policy towards securing the ownership and control of the material resources of the community so as to best subserve the common good, which means the resources of the community has to be distributed in a manner that furthers common good. And also it said that the economic system should not result in the concentration of wealth and means of production to the detriment of the common people. Right. So this DPSP Article 39 is important. I'm just flagging it off here. I'll come back to it much later. Going back to right to property, right?
See, I am boiling. Okay, if you know me at all, you know that this is something that really gets under my skin because I don't understand what this subservience to the common good is, right? And because this is something that has repeatedly been used to trample upon individual rights. This idea of the common good, right? Now, I don't. So, if you are in one side saying that there is some form of right to property, and then you say reasonable restrictions, but then that reasonable restrictions, as we've said, has to be limited, right? You can't just use it willy nilly, and then you put that entire thing under this idea that it has to subserve the common good. You're completely. I mean, you're fundamentally harming the fundamental right.
True,
Correct.
but that was the balance they could strike back when they were framing the constitution, I suppose, because a lot of these things, instead of becoming, mandatory obligations of the government, this actually became non-justiciable directive principles. So at least we can take solace in the fact that they did not insert these in the fundamental rights chapter in some way or the other to curtail your rights, but later simply said that the government has to keep these things in mind while framing its policy and laws. Anyway, going back to our story, right? Now, why did Article 19 and 31, which enshrined our right to property, became so controversial even at the beginning of the constitution itself in 1950, right? And that is because of this whole idea of land reforms. And I would love to know your thoughts on land reforms as well. But land reforms, again, there were social movements, there were political movements along land reforms for at least a century before independence, if not more. The whole idea of zamindari, the exploitative system, the feudalistic agricultural practices in the country was frowned down upon both by the political elites as well as the masses, right? Because they felt such a system should not exist in a democratic republican India. So a lot of governments started doing these land reforms through enactments, which are laws by the state governments, because land is a state government, and typically states started formulating these land reform laws. And some of them, the most important ones, were relating to zamindari abolition, fixing of land holding ceiling, which meant, a particular individual can only hold up to a certain amount of land. Rest will be taken away by the state and redistributed to others, right? And then there were laws which gave tenants the title to the land that they were, sowing, right? So land to the tiller became like the call of the action back in the day. So a bunch of these land reforms started coming in. However, it met sort of the roadblock of the fundamental right to property, right? A lot of these people who were losing land because of land reforms went to the courts, and the courts began pushing back. But before I get into that, What do you think of land reforms, Anupam?
Yeah. Fair disclaimer that whatever I say will be controversial in nature, but one, I think we have to recognize that there was inequality and injustice in the system that prevailed. So I don't think, I want to state that right up front, saying that the system that prevailed was not fair, right? With the zamindari system, that you had great concentration of wealth, and along with that power, both economic, political, and otherwise, social even, in the hands of a few people, and then the rest were left to, in many ways, were left to suffer at the mercy of this particular system. So let's put that out of the way. But the answer to that is, unfortunately, I don't think worked very well for anybody. Right? It didn't work well for anybody. And the idea is that, I think, see, this is one of those things that has happened the world over. Any time a populist, socialist, communist, authoritarian, put all of those not nice words there, kind of governments come into power, one of the first things they do is land, because land is, it's more than just an economic input into production, right? A land is a very emotional kind of commodity. It's not like a mobile phone, right? You don't have any other kind of input. A land is very emotional in nature, because there's ancestral land, it's tied to a whole bunch of other emotional aspects, etc. So one of the first things that most people in power do in order to win over voters and everybody else is try to do some kind of land reform, right? Now, the problem is this kind of forceful distributive justice is that it does take away land from a set of people without fair compensation. It assumes that everybody there is evil, as in they've gotten that land and everything else through improper means and a whole bunch of other things. Then even if you ignore all of that, they take away that land, minimize the land holdings, then carve it up into different pieces, and then try to give it away to everybody. From a purely economic efficiency lens, this is one of the worst things you can do, because what you've done is completely ruined the chances at economies of scale. In fact, you've deliberately introduced frictions. You've deliberately introduced diseconomies of scale, right? You've scaled down. And so therefore, and that's the big problem that exists in Indian agriculture today, right? That you have these small land holdings which can't produce more, which doesn't have commercial type of farming. It's really, subsistence farming, 5 people working on a farm without machinery, a whole bunch of other things, right? I would go so far to argue that many of the ills of today's agriculture goes back to this kind of land reform, right? What was the other way? We could think about, how do you compensate fairly? You can do some kind of land to the tiller. You can put it on auction. You can subsidize some other people. You can help. There's a whole bunch of things you could have done. But then just snatching land away without compensation, carving it up, and then distributing it seems to be an extremely inefficient solution. And we are kind of still suffering from it. But back to you.
Yeah, that's right. And I think fragmentation of land holdings in agriculture is a problem that still affects our agriculture sector, leads to low productivity and so on. But anyway, going back to our story, like it was not the case that there was no compensation. The courts actually started intervening early on to force the states to pay compensation wherever, the person was forcefully deprived of property, right? And the government did not like this, right? And they went to the union government, which was headed by our first PM back then, and they protested against this. So what did the parliament do? They started amending the constitution, right? This whole process of changing the constitution whenever a court says or goes against you began with the first amendment in the context of right to property. And it is important because, the first amendment provided Article 31A, capital A, which said that, whenever there is a law which provides for acquisition of estates, then it cannot be tested for violation of right to equality or other right to freedoms given in the constitution, which basically exempts the fundamental rights scrutiny to some land reforms regarding acquisition of estates, right? And what is estate? It was given a very broad definition. Basically, almost all agricultural land in the country was called estate. So now the state could sort of take over the estates, and nobody could go to the court and challenge it for violating your Article 19 or Article 14, right?
Wait,
Yeah.
that was a lot of legal jargon. Okay, let me just demystify all of that. You're saying that government wanted to take land.
Yeah.
People wanted money for that land. Government didn't want to pay for that land. So they went and just changed or introduced a law which said we can take land without paying for it. Is that a good summary?
They did not do that exactly. I think what you're talking about, they did a few years later. At the beginning, they were not so brazen. So what they said was, okay, we will give you compensation, but you cannot go to the court. That's
Ah.
what they said.
Which means then that they will pay compensation, but what we pay is up to us.
Exactly.
Okay.
Exactly. And
Okay.
this other egregious sort of thing which the First Amendment did was introduce this new provision, Article 31B, and which also inserted a new schedule in the Constitution called the Ninth Schedule. And which is crazy because, what it said was essentially the Parliament can insert any law it wants into this Ninth Schedule, and that law is exempt from fundamental rights scrutiny. Right? I
Ah.
mean, I don't know if any other constitution in the world provides for something like this, because this simply means the Parliament can insert any law in Ninth Schedule and call it immune from constitutional scrutiny, right? And this is something they use to protect land reform laws in the country.
But how did this not draw like the greatest level of whatever pushback from society? Because essentially what you're saying is that they just introduced this kind of a magic wormhole, where you can put in any law which can go against the rest of the constitution, right? Or the most fundamental part of the constitution which guarantees fundamental rights. So I mean, in effect, they could have put in anything to do with in the ninth schedule saying fundamental rights are okay, but people can't speak against the government. They could have done that, right?
They could have done that. They
could
can
have
still do it today. This exists still on paper today, right? And they could very well do that. And the pushback did not come from the society because the society was largely in favor of these land reforms, right?
Ah.
The pushback actually came from the courts, the high courts and Supreme Court in the country, because a lot of these individuals who lost land went to the court and challenged the laws which were taking away their land, right? So the courts were actually speaking up for the individuals and speaking up for liberty, right? Which is strange given the times that we live in. But having said that, what did the courts do?
Given that our last podcast was actually taking a massive dig at the courts and how they were how they've been taking away from the rights of people. But anyway, go on. Sorry.
Precisely, right? Now, what did the courts do? They said that, okay, you have this idea of eminent domain where the state can acquire land for public purposes. However, the Constitution says there's a fundamental right to compensation, and it cannot be any compensation. It means just compensation, which means it should be equal to what the owner had been deprived of, right? Now, the government suddenly sat back and started thinking, okay, we're taking all these land and redistributing it to other people. How are we going to pay, right? And back then, the government did not have as much, revenues. It did not have money to pay for the compensation that it had to pay now because the court started saying there's a fundamental right to compensation as well, given by the very constitution. So they came up with the smart idea. They brought in another amendment to the constitution, the Fourth Amendment in 1955, and it basically said that any law which fixes compensation cannot be challenged in the court on the ground that it is inadequate, right? So they are constitutionally providing that now you cannot go to the court and say that, okay, I was not paid sufficient compensation because you no longer have that right. Hai? So this was the situation.
See, this is literally exactly akin to how the person who owns the bat makes up the rules. In gully cricket, this is what happens, right? I own the bat, so he can make the rules as and when they want, which will favor them. But it's exactly like that. So they've just they're literally playing around every time the courts push back. They're introducing new laws which will somehow enable them to take basically land and not pay for it as much because they don't have the money, right?
Exactly. So there was one more amendment in 17th Amendment, not quite significant for our discussion, but I would just like to flag it because it expanded the meaning of estate to even more lands. But, despite the fact that the Constitution now said that even if compensation is inadequate, you can't go to the courts still stood up for the individual. And they found creative ways of doing this by saying that, okay, we won't interfere, but if the compensation is illusory or the principles for determining the compensation are irrelevant or do not make sense, in such situations, we will still sort of intervene and say that, oh no, the government has to pay compensation, right? So the courts were still doing this. So to sum up what the situation, before that, Anupam, go ahead.
So if the government basically, okay, let's say I have land worth 10 lakhs, government takes it away, does fix compensation, but gives me whatever, 10 rupees for it.
Yeah.
Right? They could do that under their law, but then the courts pushed back and said, we will challenge that perhaps.
Exactly, because it will be considered as illusory compensation, right? Because that amounts for nothing. But to sum up sort of the position and the development so far till 1965, so you have a fundamental right which can be restricted on public interest grounds. You also have a right to compensation, but the government is saying that the quantity of the compensation cannot be challenged before the courts. The courts are saying fine. But still, if the compensation is so negligible, then we will be forced to intervene, right? So this is the saga of right to property up till 1965.
Okay, so take a break then, because I think what we must do right now is kind of slightly jump tracks, because what I get the feeling is that the parliament is playing games with the constitution, right? They're literally putting in provisions which allows them to dilute the principles in the constitution, which allows them to dilute the fundamental rights of the which is present in the constitution. So in a way, the parliament is attacking the very nature and structure of the Indian republic. Is How was that allowed for? Was there no built-in kind of safety mechanisms within the constitution that stopped this? Hadn't they kind of preempted something like this? And then, how did it play out? I know finally it kind of, the climax is at Keshavananda Bharati, but
Yeah.
how did it play out before that?
Yeah. So what you said raises the fundamental question, what is the extent of the parliament's power to amend the constitution, right? Now, can the parliament replace the entire constitution? Can it substantially alter it? Can it make only minor improvements? So what is the extent of these powers, and are there restrictions on the powers of the parliament to amend the constitution, right? That is the fundamental question. And this has been litigated in our country from 1951 onwards, right? Because the first amendment that I mentioned was actually challenged before the court. But the Supreme Court did not intervene. They simply said that, look, the Constitution only says laws which violate fundamental rights can be held to be unconstitutional. It does not talk about constitutional amendments. So they said a law is not equal to a constitutional amendment. So if the parliament wants to violate your fundamental rights, it can take the recourse of making a constitutional amendment and not through a law. And if they do that, then the courts can't intervene, right? However, over time, the courts shifted its position. In 1967, we have this famous case of Golaknath versus State of Punjab, where the first 14, the first, fourth, and the 17th amendments were all challenged, and the court had to decide whether the parliament has unrestricted powers to amend the constitution or not. And interestingly, right, in 1967, the court gave a decision where they held that the parliament's power to amend the constitution is restricted. They're going to treat a constitutional amendment as a law and check it for any violation of fundamental rights. So all these constitutional amendments which had played around with the right to property, which was a fundamental right back then, cannot continue. But after having said that the parliament's powers are restricted, they sort of copped out, right? What did they do? They did not hold all these first, fourth, and 17th amendments as illegal. They said we will apply something called the doctrine of prospective overruling, which basically means that our decision will only apply henceforth. In future, Parliament cannot amend the constitution to take away your fundamental rights, but we're not going to do anything about the past. This is something weird which they did. But Golaknath was still monumental because it's the first time the court is saying that the parliament does not have unbridled powers to amend the constitution in a way that it pleases, and especially it cannot take away your fundamental rights.
Okay.
So
that is a monumental moment, right? I mean, in
Yeah.
kind of how this playing out. The reason why I find this fascinating, Sri, even though it's partly legal subject, which is usually extremely boring for most people. The why I find this fascinating is because there are three things playing out, right? One is this entire, I mean, it almost feels for me like a Christopher Nolan movie where there are like three stories and we're going back and forth and, it all culminates at one place. But so on one side is just the right to property bit, right? And how that's playing out. The second is this battle between Supreme Court and the Parliament on the supremacy of the Constitution, as you say, right? And that's kind of playing out, saying what can Parliament do, what can't Parliament do, and so on. And the third bit, which kind of and is very important in kind of contextualizing all of this, is the role of the state in our society, the role of state in individual, role of state in the economy, and so on. And the right to property is kind of stuck in this in this kind of big debates and this kind of turning point in India about the big economic and the political orientation of the country, right? Because on one side, I mean, India since the 1950s was kind of socialist. Was definitely, you couldn't say it's capitalist, but there was elements within the constitution which actually said the right to property is fundamental to being a capitalist society, right? You can't have capitalism without right to property. We'll get to that later. But on one side there is that bit. But when Indira Gandhi takes over, and there's a very clear kind of um, further kind of cranking towards the left, right? If Nehru was socialist, whatever that Fabian socialism, etc., Indira Gandhi wants to double down on it
Yeah.
and make it completely kind of this thing, right? So there's a whole bunch of things going on there where there's nationalization happening. There's there's this as I said, when you want to consolidate power, one of the easiest ways to do it is to do land reforms and literally take away land and redistribute it and a whole bunch of those things. So now we'll bring in that bit as well. You bring in that context of this turn towards socialism in India, or greater turn towards socialism in India, and we'll see how these three things play out. Back to you.
Exactly. Right. And to put it very simply, Nehru was a socialist while Indira Gandhi was a socialist on steroids. Right. So that's basically started. That basically started happening in the late 60s when Indira Gandhi comes into power for the first time. And now the agenda, the socialist agenda, has sort of moved away from land reforms to nationalization. Right. Because she feels all these industries are owned by these private individuals who are not doing enough for the society, who are not doing enough for the people. There's a lot of economic inequality and so on. So, what should the government do? The government should start nationalizing all these industries and start taking control and start doing business on its own, right? And one of the first things she attempts is bank nationalization in 1969, which was done through an ordinance initially, and later a parliament also approved the law which nationalized around 14 private banks. And this actually went up to the court in a case called R.C. Cooper, where the court, now it was emboldened by the Golaknath judgment. It said that the parliament cannot do anything and get away with it. So the court actually struck it down. They said that this bank nationalization is illegal, right? So Indira Gandhi was taken aback and she did some crazy things, right? And I'll come to that. But before that, your thoughts on nationalization, beginning with bank nationalization.
How much time do you have? Bank nationalization is one of the, again, it remains as perhaps one of the biggest kind of detriments to Indian growth story way back then. So I don't want to go because it's a very contentious kind of topic that, according to me, has derailed Indian growth for a very, very long time, right? And even today, we are struggling to kind of undo the damages done by bank nationalization. So for a long time, we didn't have enough private equity. We didn't have enough capital in the banks. We came up with all of these crazy rules about who can we lend to, who can't we lend to, and then RBI again is kind of, what do you say? Their wings are clipped. Then there's all of this about priority sector lending against capitalism. There's a lot of things that have happened there. Firstly, for me, it's just a gross violation of economic rights, right? You just completely bulldozed. I mean, you see, there are parallels. Okay, so you completely bulldozed your way and just took over banks without any form of democratic recourse or to rights and so on. You just took over those banks, and then you're saying, okay, now I have all of these banks that I can play with. So for me, that was it's not just unfair and unjust and so on, but it's also, as I said, something that has consistently become a thorn in India's growth story.
Right. But after the setback of bank nationalization, right? So Indira Gandhi doubles down and she goes to the polls. This famous election in 1971, I believe, where she comes back with a huge majority. She fights on this whole Garibi Hatao agenda, and she explicitly goes to the people and tells them that, give me the seats required to amend the constitution, right? Something, again, we have seen parallels of lately. And once she comes into power, she introduces two significant amendments to Constitution again, the 24th and the 25th Amendment, right? Now, what does 24th Amendment do? Very simply, it undoes whatever Golaknath judgment said. Now, after 24th Amendment, it's clear that notwithstanding whatever contained wherever, the Parliament can amend the Constitution as it pleases. Nobody can tell it that it cannot do so, right? So she makes this explicit in the Constitution. Now, the 25th Amendment actually again deals with right to property, because right to property has sort of come back into our discussion because of the whole nationalization agenda, right? Because whenever you're nationalizing an industry, you're taking over a company, for example, you're essentially taking property from a person. So the whole issue of compensation and so on becomes all the more relevant, right? So what she does is, where the Constitution earlier provided there's a fundamental right to compensation, she replaces the word compensation with the word amount, right? And in legal sense, this is a huge difference, because compensation means you're sort of compensating somebody for what they have lost, but amount can be anything. Amount can be a token amount, right? And again, she's very clear. She's like, I can take away any industry, I can nationalize them overnight, and I do not have to pay the shareholders what the companies were. Right. And then the 25th Amendment also does two, three other crucial things. It may be a bit technical, but bear with me because it's very interesting for the later part of the story. So it introduces a new Article 31 capital C, which basically says that, remember earlier I talked about this DPSP on redistribution of common resources and removing inequalities in the economy and so on. Now, what this new Article 31C says is if there is any law which is in furtherance of these DPSPs, then it can't be challenged before the court. Right? So now, if there is any law which is about removing some inequality in the economy by whatever means, this cannot be challenged for violating anybody's fundamental rights. And the other thing that Article 31C also does is if a law declares in its text that, this law is for achieving so and so objectives, then that is final, right? The courts cannot question this, right?
So let me get this straight, Sri,
Yeah.
because this is hitting home slightly hard. So prohibition then would be completely legal because of this amendment? Because in the directive principles of state policy, you have this idea again that the state shall endeavor to do prohibition, blah 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 blah. Whereas I could technically challenge it as violation of a fundamental right. I don't know how, but I'm sure smarter lawyers than you can think of that, right? Because it's a violation of my right to drink. I mean, is that a fundamental right? See?
Yeah. So to answer your question, Anupam, basically she does what you said much later in 1976 during the emergency, right? Now what she has done, she's only restricted this provision to those specific articles regarding redistribution of economic resources and so on. So it is not all DPSPs, right? But later during emergency, she actually extends this provision to all DPSPs. And I'm consciously using the word she because she had absolute totalitarian control over the parliament, and the parliament was actually completely beholden by her power, right?
Yeah.
But moving on, now the constitution is clear. 24th and 25th amendments have come in. The courts can't question what the parliament does. Fundamental rights can be amended. Compensation need not be paid. Any amount can be paid. What she does, she sort of doubled down again on the nationalization agenda. There are some very, very jarring examples, right? Like, for example, one insurance company was nationalized whose worth was 23 lakhs and they were paid around 10,000 rupees of compensation, right? Now, what happened with the mining industry is actually quite sad because when the mining industry in the country was nationalized, the government just took over all the assets and did not take over the liabilities, right? Now, what happens when you don't take the liabilities? All the banks who have given loan will lose out, or who have loaned to the mining company will lose out. Any debenture holders will lose out. Ex-employees who have some pension benefits, etc., will lose out because technically these are all liabilities of the company on the balance sheet, right? Book debts, which means vendors and traders to whom the company owes money, lose out because the government simply refuses to acknowledge these debts, right? So this sort of tells you how socialism was in action and how this nationalization agenda was carried out, right? And this ultimately required the court to step in Keshwananda Bharti case. But I'll pause here to hear your thoughts.
No, I mean, I just listening to you. I've known all of this, but just listening to you in this context again, it really gets my goat, right? This is one of the craziest periods in Indian economic history, which I don't know how many people are truly aware of. Even before the emergency and so on, this was the period under which the Indian economy was, ruined, completely ruined, right? Because it, as you say, I mean, one, there was just nationalization willy nilly. And then, of course, you put some governments in, government boards in charge of these things, which we know how it went. If you look at, problems that came up in 2010 about your, what do you say, the twin balance sheets problem, etc. Many of that you see, the seeds of it in 1970s, right? If you see what is happening with our mining companies, all of that, again, you can come back to the 1970s and see what happened with it. If you ever ask why India did not grow beyond like 3%, 2% during this period, from the 1960s all the way up till 1991, again, the reason is what Indira Gandhi did in the 1970s, right? I mean, even some of the crazy things happened before that, but this was perhaps the most brazen, egregious, violation of individual rights that a democratic Republic of India has ever seen, right? The most.
Exactly. Yeah, the state was indulging in daylight confiscation of property and was getting away without even having to pay compensation for it, right?
I mean,
Uh,
you said daylight robbery of property without compensation. I think that's a daylight robbery will mean without compensation.
yeah, maybe daylight extortion is the right word, where the
Yeah.
state is taking it away. But anyway, leaving that aside, right? So now what happens next is we have this decision from the Supreme Court in 1973 called Keshwananda Bharati, which is very famous. Anybody who reads a newspaper would have read about it at least, because it gave us the basic structure doctrine, right? But what was the issue in this case? It is actually a beautiful summation of both the parallel stories that I was talking about today, one on right to property and the other on the parliament's power to amend. Because in this case, the Kerala Land Reforms Act was challenged by Keshwananda Bharati, who was actually a Swamiji from one of the mutts in Kerala, which owned a lot of land, a lot of which was affected due to a Kerala Land Reforms Act and so on. And it also challenged 24th and 25th Amendment. So the court sat in a 13-judge bench, which was the largest ever sitting of the Supreme Court, to decide on the two questions, essentially. One is, what is the extent of Parliament's power to amend the Constitution? And two, whether Parliament can amend fundamental rights in the context of right to property, which had been amended serially before this period, right? Now there was a beautiful 7:3 split in this decision between the judges. In fact, there was a swing vote. There was a 6 versus 6 split on one side, and there was one swing vote by Justice H.R. Khanna, which gave us the final outcome of the case. So, what did the ones in majority hold? The first 6 judges held that the Parliament's amending power is actually limited. It is constrained by something called the basic structure doctrine, which says that there are certain essential parts of the Constitution which cannot be amended. But barring that, the Parliament can amend the Constitution, right? But they also held that the fundamental right is actually an essential feature, forms part of the basic structure. Hence, any amendment to the fundamental rights can be struck down. Now, the other 6 judges held the opposite. They said the power to amend is unlimited. They can do as they please. Now, what did Justice
people and all of that, right?
Yeah. So what did Justice H.R. Khanna do now? He actually gave a middle ground, I would say, where he upheld basic structure doctrine. He said there are implied limitations on the Parliament's power to amend the Constitution in the form of basic structure. Parliament cannot destroy the basic structure. However, he said that fundamental rights are not really a part of basic structure. So your right to property is not really a part of basic structure. Uh, and ultimately, he did not strike down any of those amendments which had amended right to property in the past and sort of diluted it over time, right? But what he did, in fact, was he found that the idea of judicial review, which is the power of the courts to examine any law or constitutional amendment, is actually a part of basic structure. So this 25th amendment, which had said that, if there is any law which promotes DPSP and it says so, then you cannot challenge it in court. He held that part, that limited part, to be unconstitutional because it takes away the powers of judicial review of the courts, right? So it was like court guarding its own turf, where it is saying that, okay, Parliament can do as it pleases. However, we have the final word. We will tell you whether this infringes basic structure or not. But in the middle of this entire thing, let me just finish before I come to you again, Anupam. In the middle of this entire thing, they forgot about the right to property. And which is why I began by saying that in this battle over supremacy of the Constitution, right to property became the casualty, right? So no longer was the position that Parliament cannot amend fundamental rights. So that's where we are at.
So you're saying the fundamental rights as of today is not part of the basic structure?
No, there have been subsequent decisions which have alluded to the fact that your at least Article 14, right to equality, Article 19, which is your freedom to speech, freedom of movement, freedom of trade, etc., and Article 21, which is the right to life. And these three are also called the golden triangle, are indeed part of the right to, indeed part of the basic structure. But again, basic structure is a case by case determination, right? So it's a little bit vague by design. So we'll only know when there has been amendment to these articles and these have been challenged before the court. Until then, we won't know for sure. But it would be fair to say that, at least these important fundamental rights are part of the basic structure. Now, but there are certain minority rights in the Constitution, for example, right? But if they are taken away tomorrow by the Parliament, did they form part of the basic structure? Now, that's a good question to ask. We don't know.
Okay. So the summary of all of this is that due to Keshav Nanda Bharti case and the I don't even know how to characterize it, whether in a good light or a bad light, but because of H.R. Khanna's, Justice H.R. Khanna's interventions, the constitution per se was kind of saved.
Yeah.
Right? At least the basic structure part of it, as in that there are certain things that the parliament just can't amend. But on this altar, right to property went to die.
Exactly. And
Right?
that's exactly what happened because, in after emergency, when the Janata Party came into power, one of their promises in the manifesto was that they're going to delete right to property from the fundamental rights chapter. So what they did was very unfortunate. They deleted your Article 19(1)(f), which talked about right to acquire, hold, and dispose property. They also removed Article 31, which talked about compensation and so on. And in the place of all this, what we got was Article 300A, which simply says no person shall be deprived of his property save by authority of law. That's all. It makes no mention of any reasonable restriction. It does not make mention of any compensation or whatever. But right now, all you have is some legal right to property, which, after the 44th Amendment, is the only savior, so to speak. Which is why even when we had cases like demonetization and all, which is essentially a way of depriving property for at least a short period of time, we did not know truly whether this would stand a fundamental rights scrutiny or not, right? So that is where we are at.
Okay, so two or three very interesting things here, right? One is the idea that you have so okay, let's do this. So one, I want you to kind of explain the difference between a fundamental right and a legal right. So what just for people who don't understand this part of it, right? So what makes that difference? And second, the kind of so the way that this has evolved is that there is some form of right to property now, but that right to property basically just saves you from, let's say, encroachment of your land by your neighbor.
Yeah.
But the state can come and take it away, right? And that state can come and take it away with or without compensation. I think you'll come to that slightly later, the current status of the compensation bit. But
Yeah.
that's as it stands. Is that correct?
Yeah. So, firstly, on the question of distinction between fundamental rights and legal rights, it's very simple. Fundamental rights cannot be taken away by law, uh, unless, of course, they fall under reasonable restrictions, right? And the courts will determine whether this is a reasonable restriction or not. But for legal rights, this is something which is granted to you by the statute, by the law itself. So, this can be taken away at any point in time, right?
So, which
And
means which means even that's what National Highway Authority of India can just pass a law. I mean,
yeah,
or whatever the Department of Roadways, blah blah blah, can pass a law that NHAI can come and they can take as long as they pay something to you. That's
precisely. And
basically.
that's how most
So,
of the land acquisition laws currently are structured. They provide for compensation, of course. Things have moved. I think the political sort of consensus on this has shifted. Now there is not much talk of confiscation or expropriation of land. It is well accepted that compensation has to be paid, at least by law, right? Now NHAI and metros, etc., require special land acquisition laws which exist and which provide you compensation as per the parameters given in those laws. Now there's also a general land acquisition law passed in 2013, which talks about fair compensation and rehabilitation and so on. So there are multiple legal rights which exist, but none of these have the status of a fundamental right. Tomorrow, if the government changes, when the mood of the government changes, they can do away with it. But I would believe the political consensus has shifted. The economic consensus has also shifted. So today, yes, there is no fundamental right to property, but I believe the compensation part at least is taken care of by the laws that exist.
right. And what I have some thoughts on this, and I'll come to this later. But in this entire episode, right, what do you think is the true kind of consequence or the impact of all of this on Indian society, if you please? I mean, the fact that right to property doesn't exist. And if I'm not mistaken, in most other comparable democratic republics, right to property is there. Is that a fair statement to make?
Yes.
Right? Forget, of course, we're not talking about China and so on, but I'm saying US, Western Europe, other parts, Australia, Canada, New Zealand, blah, 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 blah. All of that has some form of right to property. And
Yeah.
India right now doesn't, except as a legal right.
Yeah.
Okay. So what is the impact of this, do you think, on I have some thoughts on this at the larger scale, which is probably a rant, mini rant, but I'll come to that later.
Sure. To put it very simply, I think there's a fundamental misunderstanding on part of our parliamentarians when they made all these changes to the constitution, and they sort of tried to remove right to property simply because they did not want to pay compensation for land reforms or nationalization agenda that they had, right? But the unfortunate part is it fails to sort of recognize that right to property is the bedrock of many other rights, right? Now, for example, what is the meaning of right to press, which is part of your freedom of speech and expression, if you can't own a printing press?
Correct.
Or if you cannot own a laptop through which you run some digital media organization, right? What is the meaning of right to move in the territory of the country and settle in any part of the country if you cannot buy a home, right? And if you cannot invest in this. Similarly, you have a right to trade, business, and occupation, a fundamental right to trade, business, and occupation. But what is the point of it if all your earnings can tomorrow be confiscated by the government because you don't have a fundamental right to property to retain those earnings that you
Exactly.
made by
Yeah.
carrying on a business profession or whatever, right? So it sort of fails to recognize this reality and fails to give adequate protection to this all important right to property, which sort of goes across different fundamental rights which have been guaranteed by the
Yeah.
constitution.
You've perfectly hit the nail on the head, because for me, many of the other fundamental rights is almost meaningless without the fundamental right to property. Right now, you can approach this from multiple angles. One, let me approach it from a purely economic kind of lens. From an economic lens, we would say that the fundamental duty of the state, the primary role of the state in markets, is ensuring property rights, right? Because if it doesn't do that, economy as we know it, the market as we know it, and capitalism as we know it cannot survive, right? And when I say capitalism, again, don't mistake it with any other faulty notions, etc. But the idea that we are a market-based society, that is, we can freely trade with each other, entirely rests upon our ability to hold on to our property, right? Because if I don't, then I'm not going to invest, and there's a whole bunch of things that will not happen. So and so now the okay, to the extent that the government will say, I'm going to protect your right to property from other encroachments, but I myself cannot promise you anything, as in I can come and take away your property as in when I please, etc. So that actually then hits at the second part of it, as you said, on all other rights that protect the individual from the state intervention, right? As you said, I mean, you can have right to life for sure, but if you take away the right to livelihood, in that sense, as in you take away my entire ways of earning money, my entire right to life is under threat.
Yeah.
Right? And similarly, political rights have no meaning. Right to contest elections or any of those things don't have meaning if I don't have a right to property. Because again, tomorrow, as you know, the government can come and seize my property, and I have no place to do any of my political activities in. Right to freedom of speech doesn't hold if I can't, as you say. I mean, if they take away my printing press, if they take away my laptop or mobile phone, etc. So I think the right to property, in that sense, was one of the most essential things to keep all of the other rights in place. As in, this idea that political rights and economic rights, these are all just categorization for our benefit, but truly all of them are intricately and intimately interlinked. You can't have economic political rights without economic rights, and you can't have economic rights without political rights. Both of them go hand in hand, which is why, I mean, for example, there is no place, there is no episode in history where you can have reasonable political rights without accompanying degree of economic rights, and part of that economic rights is your right to property. So
Yeah.
for me, this was one of the biggest kind of faults in our constitution, that we didn't foresee this and we couldn't protect that right to property.
Yeah. No, thanks for that. Absolutely. And in fact, right to property has been described as the least defensible rights because of a lot of like political and social connotations attached with it. But ultimately, all rights are human rights. And if when you look at it from that angle, civil, political, social distinctions sort of fall away, and you have to give equal protection to all of them. But having said that, a small postscript, the story is not yet over because a 9-judge bench of Supreme Court is going to give out a decision which will have a bearing on all the things that we have talked about so far. And this decision is going to come in the next few weeks. The question before the court in this case is, whether private properties can be considered material resources of the community for distributing to subserve the common good, right? Now, there's a lot of factual situation attached to it, but this is essentially the question. The court is going to rule on whether private property can be acquired by the state or distribution for common good, right? So this decision is anticipated. Let's see how the story pans out. Fundamental right to property may be dead, but the story is not yet over.
All right, that was fascinating. This spans, as you say, across multiple domains. From as we spoke about, it is about the Supreme Court, it's about Parliament, it's about the Constitution, it's about individual rights, it's about the economic freedom, and all of that and more. It also spans a history of about 70 odd years. And for me, this was fascinating to listen to. Thank you so much, Sri, for talking about all of this. I had a great ball. I hope all of you enjoyed as well. Cheers, folks. Thank you, and do join us for the next episode.
Sure. Thanks, Anupam. See you again.
If you liked our show, dive into Takshashila's research on technology, strategy, and economic affairs. Check us out at our Twitter handle @TakshashilaINST or our website takshashila.org.in.